Hello, I'm Jeff Giunta with Fleit Intellectual Property Law. In this brief discussion, I'll be looking at what patents are and discuss how to get them. First point to cover is what are patents? Patent is basically a document from the government that allows you to sue people who are doing what is protected by the patent. Something to remember is that a patent holder is required to enforce the patent. The patent holder is responsible for hiring a law firm to file a civil suit in federal court to enforce the patent. That can be an expensive proposition. The lawsuit can either ask the court to stop the other person from practicing or using patented products or systems or methods, or the suit can ask for monetary damages based either on the amount of lost money that the patent holder has suffered because someone is copying the patented product. Alternatively, the profits that a copier is making by copying the patented product or method can be given to the patent holder in a lawsuit. Something to remember is that patents are issued and protected by country. That means that if you have a U.S. patent, it can protect you from having people copy your system or method in the United States or selling a patented product. However, unless somebody is importing something from outside the country, your U.S. patent cannot affect what people do outside the country. So if someone is copying your patent, selling your product or service in another country, such as Canada or China, a U.S. patent won't be able to stop them. You have to have a patent in those countries, such as Canada or China, that is a duplication of the effort it takes to get a patent in the U.S. It can add up to a lot of money if you're trying to protect your invention in a lot of countries. There are three types of patents available. One is called a plant patent that protects horticultural innovations. Another type of patent is referred to as a design patent, which protects the aesthetic design or the industrial design of a product. Art Deco toasters or appliances, and also common things such as paperweights that have the shape of a cat can be protected with design patents. However, that patent will only protect the way the product looks. No functional aspects of the product can be protected by a design patent. The third type of patent is a utility patent. That is the only type of intellectual property that can protect a functional aspect of something. Utility patents generally protect methods, devices, or chemical compositions. And what people normally think of as a patent. In order to get a utility patent, you have to file a patent application. There are three types of patent applications. The first type, which is the only type of application that can result in having a patent issued, is called a non-provisional patent application. That application is examined by the patent office, and the examiner will determine whether or not the invention is worthy or meeting the requirements to have a patent issued. Two other types of applications do not generally result directly in the issuing of a patent, but can be predecessors to filing a non-provisional application. The first type is called a provisional application. This is really a placeholder. The U.S. has a first to file system, so the first person to file a patent application will get a patent over someone who files an application for the same patent. Also, if somebody publishes information, it's basically teaching of your invention that might preclude you from getting a patent. So a provisional application allows you to file something with the patent office that describes your invention, and as of the date you file that provisional application, you are given a priority over people who disclose things later. So it's a little bit of a placeholder. It's only valid for 1 year. So if after 1 year the provisional application goes away, it's like you did not file it. But within that 1 year period, you can file a non-provisional application and get the benefit of the date of your first provisional filing. Another type of application is referred to as a Patent Cooperation Treaty application, or PCT application. This is sometimes referred to as a international patent application. That might give the impression that it will result in an international patent that you can enforce around the world. There is no such thing as an international patent. What a PCT application allows you to do is file an application. It is examined by a patent examiner who issues a report. And the report basically says that things were found that were close enough where the examiner doesn't think you should get a patent, or the examiner will say that things close were not found, so he sees no reason why a patent should not issue. So this report that's issued does not have any binding effect on other patent offices. So once you get this report, you can go and file regular patent applications in other countries. The benefit that the PCT application gives you is that if you do file a PCT application, you have 30 months to file in these foreign patent offices. You'll get that report from the PCT application examination, but the real benefit is that you had 30 months, or about 2.5 years, to determine whether your product is going to be successful enough, or whether you want to invest in filing patent applications in various countries around the world. If the product isn't doing so well, you may decide not to incur that expense. Alternatively, you may want to have the opportunity to sell your invention to another company that would want to pursue international patent protections. So that gives you 2.5 years to try to market the invention or the patent applications themselves to other entities. But the PCT application does not result in an international patent, and it is mainly used to provide you this 30-month delay until you have to have the expenses of a lot of foreign office filings. Well, I hope this was a helpful introduction to patents and how to get them. Certainly wish you the best of luck in commercializing your invention and ideas. And if you need further information, please feel free to contact us for a free consultation.